Welcome to the lecture on post-conflict justice processes and institutions. After atrocities, justice processes can play an important role in rebuilding society. The processes are handled by either state or international institutions, and they are top-down approaches. How society deals with the legacy and memory of contentious past depends on social response to the victims and perpetrators. The state international community often lead the retributive justice processes because they have the monopoly over power within a society through courts, legal policies, and norms. ICC, or International Criminal Court, was established when the Rome Statute came into force on July 1, 2002. On February 25th, it had been ratified by 89 states from all continents. The court has the power to try persons accused of the most serious international crimes, such as genocide, crimes against humanity, war crimes. While the ICTY, or the International Criminal Tribunal for the former Yugoslavia, and the ICTR, International Criminal Court for Rwanda, are subsidiary organs of the Security Council and as such embedded in the United Nations, the ICC will be much more self-reliant. ICTY is an example of an ad hoc tribunal which was established to try individuals responsible for the mass atrocities committed first in Croatia and later in Bosnia and Herzegovina. As early as September 1991, the United Nations took note of the situation and urged parties to the conflict to abide by the international law. Thousands were injured and killed, and hundreds of thousands were displaced. The UN in late 1992 established a commission of experts to examine the situation on the ground. In its report, the commission documented horrific crimes and provided the Secretary General with evidence of grave breaches of the Geneva Conventions and other violations of international humanitarian law. Its findings led the Security Council to decide that it would establish an international tribunal for persons responsible for these crimes in order to stop the violence and safeguard international peace and security. On 25 May 1993, the UN Security Council passed Resolution 827, formally establishing the International Criminal Tribunal for the former Yugoslavia, known as the ICTY. Since it opened in 1995, the ICTR has indicted 93 individuals whom it considered responsible for serious violations of international humanitarian law, including genocide committed in Rwanda in 1994. Those indicted include high-ranking military and government officials, politicians, businessmen, as well as religious militia and media leaders. In Rwanda, for example, many who were responsible for genocide were tried in the ICTR, which is a form of retributive justice, but many more were tried through the gacaca court system, which is a form of indigenous restorative justice. There were too many perpetrators in Rwanda, and the top leadership was tried in an international court. However, the international or national courts often cannot provide the local justice necessary to ease the pain of the victims of genocide. In order to address the claims of victims in Rwanda, gacaca courts were introduced as more of a restorative justice mechanisms rooted in traditional and indigenous processes of justice. There were tens of thousands of perpetrators in Rwandan genocide, and the mass incarceration of genocide perpetrators has placed an immense burden on Rwandan courts. To ease this burden, the Rwandan government decided to delegate some cases to the traditional gacaca courts. Retributive justice diminishes the destructive power of the perpetrators and reestablishes law and order. It reestablishes power of the state and various institutions. Functioning structures are markers of stability and something that post-conflict societies are striving for. Restorative justice processes serve to reset the balance of power in society by increasing integrative power, which is a power of society to come together, recognize, repent, and forgive. It implies a rebuilding of the broken relationships and reintegration of victims and perpetrators into the society. There are other processes related to justice in the aftermath of conflict through which pain of the communities and individuals is recognized, such as deliberative processes, witnessing, storytelling, documenting. Through such processes, victims are reclaiming their power. Forgiveness is liberating, and it is through forgiveness and healing that the power of threat is transformed into power of love. There is a RECOM commission, regional commission, which was so difficult to establish in the Balkans. This commission would allow victims from all sides to voice their concerns and tell their stories of suffering. It would not be just one-sided narrative of victimhood, but it would include stories of the other. Truth commissions, trials, and reparations help societies reflect on and acknowledge past wrongs that ensures non-recurrence. Truth and reconciliation commissions are created by the state to bring official exposure of the truth. They are top-down approaches. The classic example of a TRC is the South African Truth and Reconciliation Commission. This commission gathered testimony from thousands of people and collected apologies from some wrongdoers so that they could play an active role in society once again. Because TRCs operate within a restorative justice framework, their guiding philosophy forgoes retributive processes in order to promote healing rather than further division and conflict. However, TRCs are not successful everywhere. They did not work in the Balkans, although the initiative for starting such a commission is still active. Regional Commission to determine and disclose the facts about war crimes committed in the former Yugoslavia, RECOM, has received support from many leaders in the region, but there is still a lack of political will to start the process in which victims from all sides in the conflict would be given a voice. When we talk about justice in post-conflict societies, we need to reflect on the tension between peace and justice. Some societies do not choose punitive, but rather restorative modalities of justice for the sake of peace. For example, South Africans have chosen TRCs to deal with human rights abuses and crimes against humanity committed by apartheid regime. Sometimes healing people's relationships is more important than sentencing people to prison, particularly when violence was so widespread. Thanks for listening.